I'm Colorado juvenile defense attorney Michael Becker. An arraignment, which is where the defendant gets formally charged, marks the beginning of the criminal process for adults 18 and older. But in the juvenile system, arraignments aren't always necessary. Here are 3 things to know. 1. Many juvenile cases are resolved informally without any delinquency charges being filed at all. Informal resolutions typically include counseling, community service, probation, and possibly restitution payments. But once minors have cases informally resolved without an arraignment, they need to be careful not to reoffend. If they do, the DA will be less likely to give them a second chance at an informal resolution and may proceed with delinquency charges. 2. If a minor does get arraigned, the judge may then schedule a fitness hearing to determine whether the case should stay in juvenile court or be transferred to adult criminal court. This typically occurs when the minor is accused of serious, violent, or sex crimes. And 3, if a minor's case remains in juvenile court, it will proceed similarly to a criminal case. A public defender gets assigned to the child if his or her family cannot afford private counsel. The defense and prosecution will try to negotiate a plea bargain. Otherwise, the case will go to trial, called an adjudication. And if the minor is found delinquent, the judge will then impose a sentence called a disposition. If you've been arrested in Colorado, call my legal team 24/7 for a free consultation at 303-222-0330. The attorneys of the Colorado Legal Defense Group will fight to get your charges reduced or dismissed.